Well, good morning, everyone. I'm honored to be here today with our distinguished panelists, all of whom I consider friends, and I hope everyone here appreciates how fortunate we are, other than myself, to have such distinguished scholars and practitioners with us. As Pat mentioned, my name is Schaerr. I'm a lawyer practicing in Washington, D.C. I'm also an adjunct professor at Fred's institution, the BYU Law School, where I have the privilege of teaching a course on religious freedom litigation and courses on Supreme Court advocacy. I'd like to begin with a bit of early American history that I think sheds some light on the issues that we're addressing today. In the late 1700s, an important event occurred in this building that I have on the screen here, which was the old Connecticut State House in Hartford, Connecticut. Nor am I talking about the ratification of the First Amendment and the rest of the Bill of Rights, which became law in 1791, although without Connecticut's endorsement until much later. Instead, I'm talking about the Connecticut legislature's decision on October 11, 1792, to address the plight of a minority religion known as the Quakers. For 100 years, the Quakers had been persecuted throughout New England and elsewhere for their theology, including their opposition to war or the use of force of any kind. But by 1792, when the Connecticut legislature convened, philosophers and more enlightened Christians had persuaded a wide segment of society that the best way to deal with dissenters was toleration and not persecution. And that, absent the gravest danger to the community, people should be allowed to live according to the dictates of their own consciences. And so on that day in 1792, after the First Amendment had already been in effect for a year, the Connecticut legislature passed this law which exempted Quakers from laws that generally required able-bodied men to train with the state militia and thereby ensure that the fledgling nation was prepared for military threats that even then were on the horizon. And so the provision read, "Any of the people called Quakers who shall produce to the commanding officer of the local militia a certificate that such person is a Quaker, he shall be exempt from equipping himself or doing military duty as required by the other provisions of this act, on his paying the sum of 20 shillings to such officer," which was a very nominal sort of fee. And so on that day in 1792, the legislators that adopted this exemption undoubtedly did so knowing that some of their sons and brothers could well go to war and die or be injured in place of the Quakers who, under this law, would claim the exemption. Now that, I would submit, is the ultimate third-party harm, putting your life at risk. So with that history as a backdrop, I'd like to explore with you an important question on the proper interpretation of the First Amendment's Establishment Clause, which Richard has talked about a little bit this morning. Now, a number of lawyers and scholars, including Richard, and he knew I was going to use this brief. They have asserted something like the following proposition, and this is from a brief that Richard filed in the Holt versus Hobbs case in the Supreme Court. At page 9 of his brief, Richard says the Establishment Clause forbids accommodations that would meaningfully burden third parties, and you got a hint of that from Richard's presentation today. And then later on page 13, the brief refers to what it called a general rule against accommodating religion in ways that burden third parties. Again, based on the Establishment Clause, or at least that's how the argument goes. So the question I want to explore with you is this really law, or is it scholarly opinion, however compelling it might be as scholarly opinion? And this is an important question because if the law really prohibits exemptions that risk harm of some kind to third parties, then obviously legislators shouldn't enact them regardless of their merits. But if this rule against third-party harms really isn't law, then legislatures remain free to enact those kinds of exemptions if they feel they're justified on the merits, as the Connecticut legislature did in 1792. So how do we tell if these statements are really law? Well, when one says the First Amendment requires or forbids X as a matter of law, that statement has three possible meanings. One meaning might be, well, the amendment forbids X of its own force, okay? Another possible meaning is that our historical understanding, the traditions surrounding the enactment of this amendment, forbids X. Another possible meaning is that the Supreme Court's interpretation of the First Amendment forbids X. And so if any of these is satisfied, it's fair to say that the First Amendment forbids X as a matter of law. But there's also a fourth possibility, which is my own interpretation of the First Amendment forbids X. And of course, if that's the basis for the statement, then it's not really law, it's opinion. So let's examine the third-party harm rule in light of the first three of these criteria. The first one is, does the Establishment Clause itself forbid accommodations that create third-party harm? Well, here's the language of the Establishment Clause, which was drafted by James Madison in 1789 during the first Congress under the new United States of America. And if you look at that language closely, you'll see three significant features. First, beginning at the end, the provision deals with what's called an establishment of religion. Well, what does that mean? What did that mean to the people who wrote and considered and ultimately ratified that language? Well, history indicates that at the time, this language meant an official, state-sponsored church. Like the Congregational Church, that was still Connecticut's official religion in 1792, and in fact, the Congregational Church remained the official state church of Connecticut until 1818, more than 20 years after the First Amendment was adopted. And a state church, of course, benefited from such things as state-mandated attendance, taxes that would go to support the church, and those sorts of things. So if somebody had suggested to our Connecticut legislators considering the Quaker Exemption in 1792 that if they granted a military exemption to the minority religion, that is the Quakers, that they were somehow establishing Quakerism in violation of the First Amendment, they would have found it preposterous. They would have said, we know what an established church looks like. We have one right here, and we know that the Quakers are not the official established church of Connecticut. Anyway, if you continue looking at the language of the First Amendment, the provision is also directed at Congress, not at state governments. And here again, the drafting history of the Establishment Clause tells us that this was deliberate. Madison originally wanted to prohibit the states as well as the federal government from officially sponsoring churches, but he didn't have the votes to do that in the first Congress. And so he limited the reach of that provision to Congress itself. And then third, the clause prohibits Congress from passing any law, quote, respecting an establishment of religion. It doesn't directly say Congress is prohibited from establishing a national church. It prohibits Congress from passing any law respecting or having to do with an establishment of religion. And you might ask, well, why would Madison choose that word? Well, and the reason is that in 1789, there were at least 4 states, Connecticut, as I've already mentioned, plus Massachusetts, New Hampshire, and South Carolina, that still had official state-sponsored churches. And those states obviously had representatives in Congress. And those representatives apparently didn't want the national government meddling with the state-sponsored religions in their states. And so Madison agreed to keep Congress out of the establishment business entirely. That is, Congress not only could not establish a national church, but it also couldn't do anything to interfere with the state-established churches that already existed. And so the respecting language in the Establishment Clause, as Justice Thomas recently noted in a decision in the Town of Greece case, the respecting language simply meant Congress can't pass any law on the subject of religious establishments. So for all these reasons, no reasonable observer in 1789 would have thought that the Establishment Clause's language forbids any religious exemption to a generally applicable law, whether or not it imposes some harm on third parties. Well, let's go to the second question. do the traditions surrounding the adoption of the Establishment Clause forbid accommodations that create third-party harms? As Justice Kennedy noted for the majority in the Town of Greece decision, it's not necessary to define the precise boundary of the Establishment Clause where history shows that the practice is permitted. So what does history say about religious exemptions that risked harm to third parties? Well, we've already discussed the 1782 Connecticut statute that exempted Quakers from military duties. But in fact, there were a number of other states that had similar exemptions for Quakers and other conscientious objectors. And in fact, a wonderful article published in 2006 by our luncheon honoree, Professor Laycock, describes in detail the history of Pennsylvania's adoption of a similar exemption in 1757. And I love the language of this exemption. It says, every of the persons as aforesaid enrolled shall be, anyway, there was a Pennsylvania law that required people to be, quote, sufficiently armed with a good musket, with a fusee or other firelock, and with a cartouche box filled with 12 or more cartridges of powder, 12 or more sizable bullets, and 3 good flints. So that was a law, that was an obligation that Pennsylvania law imposed on everybody, but you can see in the language that I've italicized there, the people who conscientiously scrupled the use of arms, that is, people who conscientiously objected to the use of arms, were exempt from that law. And there were a number of other exemptions like that were passed during the colonial era and during the early period after the adoption of the Constitution, both with and without established churches. That exempted people from military obligations, which were widespread throughout the colonies at the time. Well, another religious exemption that was well established during the founding era was what we call the priest-penitent privilege, which prevents disclosure of confessions in court. That privilege obviously had and still has the potential to harm third parties by depriving them of information that might advance their position in litigation. Another tradition going back almost to the founding was the practice of exempting those with religious objections to slavery from laws requiring the return of fugitive slaves. And although that wasn't a statutory exemption, at least that I've been able to find, it's clear from history that there was a settled tradition of exempting people like that from those laws that relied mostly on jury nullification when those prosecutions occurred, and where jury nullification failed, on executive clemency. And there are several examples of presidents pardoning religious people from convictions based on failure to comply with the fugitive slave laws. And that obviously had an adverse effect on third parties as well, namely the slave owners. So like Professor Laycock, I haven't been able to find any contemporaneous suggestion that any of these kinds of exemptions, or the many others that existed at the time, might violate the newly enacted Establishment Clause, or any of the other establishment clauses that the state legislatures had enacted during this period. So, in short, the traditions surrounding the adoption and the early enforcement of the Establishment Clause, to my mind, not only provide no support for a third-party harm rule, but they refute it. The final question is whether Supreme Court interpretations of the Establishment Clause forbid accommodations that impose harm on third parties. And there, the short answer is no. With one exception, the Supreme Court has consistently rejected those kinds of arguments. The first was a case that arose nearly 100 years ago, after the First Amendment had been the law for over 125 years. In a case called the Selective Service Draft Law cases, the Supreme Court specifically upheld the federal conscientious objector exemption against an Establishment Clause challenge. And the court's holding occupied less than one sentence, and it said, in more polite legal jargon, this argument is so silly it requires no response. Another example is a case that arose in Utah and involved the Deseret Gym. I don't know how many of you grew up in Utah, but I grew up part of the time in Salt Lake City, and I used to play basketball and swim at the old Deseret Gym. And it became the subject of a case known as Corporation of the Presiding Bishop versus Amos. And in that case, the LDS Church, which owned the gym, had fired a janitor for failing to live up to temple recommend standards. And so the employee sued under Title VII, and the church invoked an exemption in Title VII that exempts religious discrimination, which was what that employee claimed. So the employee then turned around and challenged the constitutionality of that exemption on the very ground that is urged by proponents of the third-party harm rule, namely that this exemption imposed harms on third parties and was therefore a violation of the Establishment Clause. But the Supreme Court unanimously rejected that argument, holding that the exemption did not, in fact, violate the Establishment Clause. There was some disagreement over whether that principle ought to apply to, whether the holding ought to apply to church-owned companies in general or just to nonprofit companies. But the court didn't suggest that any third-party harm rule might actually apply more generally. Now, the closest the full court has ever come to the third-party harm rule is a case called Caldor versus the State of Thornton, which involved a Connecticut statute that gave workers the workers in private companies, the right to be off on any day of the week that they chose. So as I said, the Supreme Court in the Caldor case did in fact hold that this statute that I've described violated the Establishment Clause, but not on the basis of any general third-party harm rule. The court held that this particular law had the impermissible effect of advancing religion because it forced private employers to give conclusive weight to the interests of religious employees. And the case thus involved not an exemption from a government mandate, but a preference that allowed believers to impose the cost of their decisions on others in the private workplace. And moreover, the main Supreme Court decision on which Caldor relied, a decision known as Lemon versus Kurtzman, has since been gutted by the Supreme Court itself in later decisions that came after the Caldor case. And so, as Justice Scalia said of the Lemon decision, the Caldor decision is like a ghoul in a horror movie that gets trotted out occasionally just to scare the children. Now, the absence of any general third-party harm rule is confirmed by the Supreme Court's reaction to this same argument in the Hobby Lobby case from just a couple of years ago. And there, the 5-4 majority held that a religiously oriented for-profit company was entitled to a religious exemption from Obamacare's contraception mandate, despite the disadvantage that would impose on the company's female employees. And although Justice Ginsburg's dissent for 4 justices harped on that potential disadvantage, her dissent, in fact, did not articulate or adopt the rule against third-party harms that was sought in that case and that was summarized in the brief that I showed you earlier. And we can talk more about exactly what she did say, but she didn't actually adopt that rule, although she did talk somewhat about the possibility of third-party harms. And so the bottom line is that the third-party harm rule has never actually been articulated or adopted by a Supreme Court decision. For all those reasons, I think it's fair to say that the third-party harm rule is not law under any reasonable understanding of that word, and that means that as the Connecticut legislature did in 1792, we have to confront in each case the hard question of whether it makes sense to grant or withhold a religious exemption. For example, is it really necessary to force small wedding service providers like Elaine Huguenin, the photographer in this picture, or Baronel Stutzman, discussed by Richard earlier, is it really necessary to force people like that to choose between closing their businesses or lending their artistic talents to ceremonies that they believe are sinful and will thus put their eternal salvation at risk, especially where those seeking their services have plenty of other options, which was established in both of those cases? Do we really think an enlightened society needs to do that to further its view of equality? Those are the kinds of questions I think we need to be asking, and as Fred and Richard have done in their presentations today, I think we need to be asking those kinds of questions rather than worrying about whether a proposed exemption is really foreclosed as a matter of law by the Establishment Clause. And with that, I'll turn the time over to Reubenn to discuss some of these exemptions on the merits.